Now let us discuss what are the ethical considerations for journalists. Media acts as a watchdog in democracy, and journalists should not only be ethically correct but also legally correct. Media do not only cater to public straight, but their instant impact is irreversible. It helps in forming public opinions, which leads to strengthened media responsibility to be ethical. It should be unbiased, transparent, and based on materials, facts, and figures. Journalists should not publish anything defamatory without enough verification. A journalist can be guilty of contempt of court in the cases where their act disturbs the eyewitness in any case in any manner. Defamation is covered under Section 499 of the Penal Code. It has been described as whoever by words either spoken or intended to be read, or by signs or by visible representation, makes or publishes any imputation concerning any person, intending to harm or knowing or having reasons to believe that such imputation will harm, the reputation of such person is said to defame that person. The Indian law of defamation is divided into two types, libel and slander. Libel includes written or published defamation, and slander refers to spoken or oral defamation. Now let's discuss the print media laws. The Press Council of India was founded by the Government of India in 1966 under the Press Council Act of 1965 with Justice J.R. Mudhokar and was later revised on 1st January 1976. It is a statutory body created by the Press Council Act consisting of journalists, academicians. The Press Council of India Act is recognized for protecting the freedom of the press and maintaining and improving standards of both newspapers and news agencies. It is an autonomous body which formulates code of conduct and guidelines for the press, which is followed by members of the press voluntarily. The Press Council of India enjoys powers equivalent to a civil court and can enforce people to take an oath. The main objective was to look after the independence, subjectivity, and objectivity of news presentation. The purpose was to foster the development of press, shielding it from the external pressures and control its conduct matters such as objectionable writings. Let's discuss electronic media laws. The Prasar Bharati Act runs for the creation of Broadcasting Corporation to describe its structure, purpose, and rules. The Act received the permission of the President of India on September 12, 1990. After being universally passed by Parliament, it was implemented in September 1997. It provides autonomy to All India Radio and Doordarshan, which were previously under government control. Under this Act, all the assets, property, liabilities, debts, and legal proceedings involving Akashvani, All India Radio, and Doordarshan were relocated to Prasar Bharati. The common rules of conduct in advertising comes under the Code for Commercial Broadcasting, which highlights the ethics of practice for radio and television advertising and advertising agencies. It discourses the practice for the implementation of the code, provides excerpts from the Code of Principles allotted by the Advertising Council of India, and includes the Code of Standards with reference to the advertisement of medicines and treatment. No advertisements should be acceptable which mocks at any caste, race, creed, color, or people except for the specific purpose of effective dramatization in combating prejudice. The All India Radio Code broadcast on All India Radio by individuals would not permit anything related to criticism of friendly countries, anything obscene or defamatory, violence on religions or community. It also caters to the provocation to violence or anything against maintenance of law and order, and anything amounting to contempt of court. The attack on political party by name and aspersions against the integrity of the president, governors, and the judiciary should be taken into consideration. Anything showing disrespect to the Constitution or advocating change in the Constitution by violence and hostile criticism of any state or the center, but advocating changes constitutionally should not be debarred. Now let us discuss cyber media laws. Information Technology Act was commended on 17 October 2000 and is a primary law in India which deals with cybercrime and electronic commerce. The bill was passed in the budget session of 2000 and was signed by the President K.R. Narayana on 9th May 2000. Cybercrime is carried out by means of internet and electronic commerce. The Act aims to deliver legal recognition for the transaction carried out employing electronic data interchange and other means of electronic communication, which is commonly known as electronic commerce. It deals with legal aspects concerning digital signatures. Tribunals appeal to the High Court and deals with certifying authorities who are licensed to issue a digital signature certificate. The digital signature is a way to ensure that electronic document, which includes emails, texts, files, spreadsheets, is authentic. Authentic means when the owner will have the right to use the specific content or document. There are a total of 94 sectors, 13 chapters, and 4 schedules in the Act. The modification in the Act was done in the year 2008 and known as IT Amendment Act. The person of other nations can also file the case. For example, if any person has brought anything from Indian company, she or he can file a case against that specific Indian company. The important section of IT Act deals with using a password of other, tampering with computer source documents, hacking with the computer system, and receiving stolen computer or any communication devices, publishing images containing sexual act and child porn. The Right to Information Act RTI was approved by the Parliament on 15 June 2005 and started working effectively on 13 October 2005. The Act provides a legal outline of people and democratic right to access to relevant information which comes under the control of public authorities. The aim was to support accountability and transparency in the working of every public administration. The function of right to information was to strengthen the foundation of democracy, actively involving citizens in decision making, make administrative responsive, and reduce corruption. Any citizen under this Act may appeal information from a public authority or a body of government which is required to answer within 30 days. The individual can submit in writing or through electronic means in English or Hindi or the official language to the Public Information Officer. RTI also involves public authority to automate their proceedings for varied diffusion and to circulate kinds of information which includes facts and figures collectively. To conclude, the ethics which includes interdependence, truthfulness, objectivity, and freedom of information are very argumentative issues before the mass media in the current scenario. There is a need to discuss the attempts by both the media and government about the formulation of codes of ethics to address the individual issues and concerns in the society. I hope you had a great learning in today's session. Thank you.